We have built our firm around one idea: to lead our clients from where they are to where they want to be. But the ability to deliver the leadership and service our clients deserve doesn't happen by chance. It's a product of who we are. We are engaged, diverse, and innovative thinkers who go above and beyond what is expected because we know our efforts will carry us to achievements others never thought possible. We are unafraid to take the necessary risks that lead to new successes. We embrace change because we know sound principles will guide us through new opportunities. We are committed to empowering our people, our clients, and our communities to become every part of what they aspire to be. We are persistent on our journey forward. It is our openness to collaboration, our desire to achieve better, our character, our vision, and most of all, our people that make us who we are. That's the HB difference. We are Husch Blackwell.
Hello, everyone. I'm Danny Cooper, an attorney in Husch Blackwell's Energy and Natural Resources Group. Before we begin, I would like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit via the question box. We will try to answer all questions during the webcast today, but if a full answer is needed or we run out of time, it will be answered later via email. A PDF of the presentation is available in the resources folder. This program has been approved for continuing legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with the recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. That is all for the housekeeping items. Let's get started with our program. Joining me today is Brian Pullen and Eric Lausten. Brian is a partner in our Energy and Natural Resources Group and guides clients at each stage of their project, from idea through implementation and beyond. Throughout the framework of a project, site planning, design, financing, and sale, Brian's goal is to negotiate transactions that protect clients for the long term. Eric brings more than 20 years of experience, including serving as the legislative director in 3 congressional offices, and most recently as chief of staff to Democrat Congressman Daniel Lipinski, a role he held for nearly 8 years. While serving for Representative Lipinski, Eric acted as lead policy and political advisor, providing oversight for the congressman's active legislative and policy program. Today, we are going to discuss minerals and the mineral due diligence that should be put forth, common issues we see in minerals and in all real estate, risk mitigation, and title insurance. This discussion will be a general discussion, but each project should be looked at on a case-by-case basis to make sure the correct agreements or curative measures are addressed. We will try to get to any questions at the end of Eric's presentation. However, if we can't get to them, we will follow up with an email answering your questions. Now I'm going to turn it over to Brian to discuss minerals.
Thanks, Danny. I'm going to start it off with a poll question. And it's, have you had a renewable energy project that had mineral issues, either with mineral development or mineral owners? And just a yes or no. And I'll give a few seconds to let those come in. All right, let's see what the results were. So what I figured, 70% of the audience has had a mineral issue. So let's do a discussion on that. Let's start off with just the basics of mineral ownership. And as you probably know, since many of you have had mineral issues, is minerals can get severed, and that means that you're going to It's going to be separate between the owner and the surface estate and the mineral estate. And as you probably are well aware, it's not uncommon to have more than a handful of mineral owners. In the chain of title, there can be multiple reservations, so you have to look at each one individually. But for example, in Texas, you can have a executive owner, which that owner would have the executive rights and be able to make a lease. You can have a non-executive owner who doesn't have any right to lease, or you can have a non-participating owner who is just wants the mineral interest. He or she's not worried about any right to lease. They just want to take royalties. So not all these owners need agreements. So it's important to understand each agreement and who owns what. And the mineral estate in most states is the dominant estate. The idea that you can't access or use the surface, or that if you can't access or use the surface, you can't develop the minerals. In Texas in particular, for years, the laws encouraged development of minerals. And as we'll discuss a little bit later, we may be seeing a little bit of a shift on that, but it's still the law. And in the event there's a conflict between a mineral lessee use of the surface and a surface owner's use of the surface, the mineral lessee's use typically is going to supersede the surface owners. And of course, there's limitations to that. And there's a broad right that I just discussed, but as I mentioned, limits do exist. So a mineral lessee's right to use the surface of the land to search for and produce minerals is subject to a certain list of factors. And the lessees, or it could be a mineral owner if they own the minerals and want to develop on their own, they must be reasonable. And depending on the state, the accommodation doctrine may apply. And it has to be for the benefit of only those minerals under the land. And that can be, there's some caveats to that. And it has to be in accordance with their agreements. But those are the general concepts. And when we look at we're looking at what is reasonable. The use of this, it must be reasonably necessary to develop and produce those minerals conveyed to the land. Activities that a mineral lessee typically can do is seismic test, building structures on the land for the production of storage of the minerals, roads, water wells, water pressure wells, saltwater wells, but it has to be reasonable. A mineral owner can't obviously go and put a solar project because they don't have those rights. There's different factors that are usually determined, but obviously it would be what is customary. Is there alternative methods that the mineral owner can use, and are there alternative surface uses that the surface owner could do? And as I mentioned, we also have the accommodation doctrine in Texas and several other states, and we'll discuss that in more detail, as there's been some developments, especially in Texas, on that. But the accommodation doctrine creates an exception to the mineral estate as dominant rule, and in general, it requires the mineral owner to accommodate the surface use of the surface owner. Now, the other factor is a mineral lessee's use of the surface must be for the purpose of attaining and producing only those minerals under the corresponding surface estate. You can't own minerals on one tract of land and try to develop them on another tract of land. And the Texas Supreme Court has held that. Now, there is an exception to the rule, and that's pooling of oil and gas, which is not as relevant to this discussion. The final factor is that it has to be in accordance with the terms of the lease, and those oil and gas leases typically will specify limitations that the oil and gas lessee can do or specific locations. So you can also analyze the leases to find out exactly where a oil and gas lessee is allowed to drill. I'm going to turn it over to Danny now to discuss some mineral due diligence.
Thanks, Brian. So we are going to start with another poll question. And the question is, what types of mineral due diligence have you conducted on your renewable energy project? And A is mineral reports, B is search of online records for permits or well locations, C is both A and B, and D is none of the above. And I will give you about 30 seconds to answer that. Okay, now let's see what the results are. It looks like what I was kind of expecting, that everyone's kind of had both. So it looks like about 55.7% said both of the above. Now we're going to discuss mineral ownership reports. So a developer cannot rely on a title commitment or a pro forma by itself. So the title company is not required, because the title company is not required to search out all of the mineral interests, because they are not insuring the mineral estate. So the title policy only insures the surface estate, but the title company will want to know the mineral ownership in order to issue the endorsements and express coverage, which we'll talk about more here in a little bit. So the first step is for the developer to hire a mineral land company to conduct a title search of the minerals. So the mineral company will search county records for mineral severances and any active oil and gas leases that may be encumbering the property. So once they have that information, they will put together a mineral ownership report. This report sets forth what the mineral company sees the mineral ownership as, and it will also include a list of all the documents that the landman who searched the records found. So typically, this will be reviewed by the attorneys representing the developer to confirm whether they see any issues with what the landman found. And a lot of times in these reports too, there'll be other, there's curative items that are on there that the landman will note that we'll have to go search. So not only will it show the mineral ownership, but it'll provide curative comments as well. So there are three main reasons mineral ownership needs to be determined. The first is that the title company will require surface use agreements or set-aside agreements to be executed by the mineral owners to issue the endorsements that the developer needs on the title policy, and they will also want to see just this ownership to ensure the developer is obtaining the agreements from the correct parties. Another reason is the developer needs to know if there is any oil and gas activity around the area that is active. So generally, the attorney representing the developer and the mineral title company can do this in conjunction with one another. So you should do this at the same time. Also, knowing the activity in the area helps the developer negotiate with the title company on the percentage of mineral owners that need to execute the surface use or set-aside agreements. It also helps the developer in siting of the project. Finally, a developer will need to make payments to mineral owners for these set-aside agreements. Without knowing the mineral ownership, the developer cannot be confident who they are making these payments to. And these payments will vary depending on the location, just so you know. It really matters on the development, the current development, past production. So these payments can become significant depending on the area the project is located. So it's really good to know just who owns what and to make sure you're paying the right person. So mineral issues do tend to be more of an issue in solar versus wind because the panels could cover most of a section of land. In a wind project, the facilities do take up less of the section, and typically a mineral owner or oil and gas developer, or even a mining developer will not have any issue with being able to develop the minerals with the wind project. Thus, title companies will typically only require set-aside or surface use agreements for solar projects. However, it is important to understand mineral ownership in oil and gas activity in the area for a wind project, especially in the locations of the transmission line. We have seen, issues where there was an oil and gas lease that was still active because it was being held by production, and the current owner of the oil and gas lease wanted to, and they had the right to drill a new well under this lease in very close to where the developer wanted to run the T-line. So, this created an issue as the oil and gas company was attempting to block the transmission line from being built, and they basically argued that it interfered with their ability to drill the well. It was important that the developer knew the mineral ownership, even on this wind project, so they were able to negotiate with the oil and gas company and come to an agreement on joint development. So now we're going to talk a little bit about the Texas Railroad Commission. And as mentioned, another step a developer needs to ensure is done is conducting a search of the Texas Railroad Commission. So the Texas Railroad Commission includes a GIS map which shows active wells, plugged wells, dry hole, permitted wells, among other items. So this review is just really important for the planning and siting of a project. An oil and gas developer will file a permit with the Texas Railroad Commission prior to starting their oil and gas operations on a section. So every section of the project needs to be reviewed to determine if there is any oil and gas activity being conducted on the project or if any permits have been filed. So if there is already activity or permits are filed, this will help the developer in siting of their project, and also it will alert the developer to set areas for oil and gas activity. So it also will help the developer in the negotiations with the oil and gas developers, as they will know where this developer plans to drill. So, if there's activity or any active leases, the developer will need, they may need to obtain surface use or set-aside agreements with the actual oil and gas developer in addition to the mineral owners. So on this, note that oil and gas developers do move pretty quickly, especially in Texas and basically, anywhere in the U.S. So the Texas Railroad Commission may not show all of the permits, but it does give the renewable energy developer an idea of where activity is located. So as we previously discussed above, while solar projects do typically create more issues for oil and gas activity, the Texas Railroad Commission also should be checked for wind projects, especially at the transmission line, collection line, in any type corridor locations. Basically, you need to check the project or the boundaries of the project where facilities cannot be relocated. Those are the most important to check for wind projects. So the Railroad Commission can also be searched to determine limitations for oil and gas development in an area. So for example, there are state and county-wide spacing rules that oil and gas developers must comply with. So by doing a search of the Railroad Commission and checking the spacing and density requirements, we can generally determine whether the developer's proposed design leaves enough space for oil and gas development. So that's definitely something that should be checked. It will also help set aside areas with mineral owners and developers in obtaining the surface use agreements that we'll need to obtain. Now, besides Texas, and other oil producing states, it's just very important to determine the impacts of oil and gas or mining on a project in every state. So, I know a lot of people think of Oklahoma, Texas, and some other states as, the prime oil and gas states, but it's surprising, it's actually very surprising to see how many states do have active oil and gas projects within them. So even states, so at the beginning of a project, one of the first steps we recommend doing is performing due diligence regarding oil and gas or mining activity. So just like in Texas, we recommend doing that. So when determining if there is an oil, gas, or mining production in a state, other than Texas, or, in a state that you're not familiar with, the first thing you should do is just locate the state agency that is, tasked with keeping the oil and gas and mining records. Typically you'll be able to locate this information in an online database or through a GIS map format like they have in Texas. So if the agency uses a database format, it will include the documents that the operator is required to file, such as the application, completion reports, they'll have permits, and they'll also have plugging information and things along that nature. So as we discussed for Texas, if the state uses a GIS map to show its well and mining information, the map will show active wells, plugged wells, dry holes, permitted wells, and among those other well information. So like in Texas, an oil and gas developer will file a permit with the appropriate state agency prior to starting their oil and gas or mining operations. So when performing this review, every section and parcel in the project needs to be reviewed to determine just, whether there's any oil and gas wells or mines on the project, or if any permits have been filed. As we discussed earlier, if there is already activity or permits filed, this information will help the developer in siting of their project, and it will also just alert the developer to set areas for oil and gas activity. It also will help the developer, in the negotiations with the oil and gas developers, so they just know where the oil and gas developer plans to drill, which is extremely important. So if there is activity or any active leases the developer may need to obtain, and the title company will generally require, as in Texas, surface use or set-aside agreement with the actual oil and gas developer, in addition to the mineral owners. And now I'm going to turn it back over to Brian to discuss risk mitigation.
Thanks, Danny. And the first slide is just something we've mentioned numerous times, but it is much more favorable for a wind project to be situated, just because of the turbines not being the collection lines not blanketing the entire area. But that doesn't mean, again, that you shouldn't be checking minerals on wind projects, and that solar can't be developed during in an area that's actively developed. It just means that we need to look much more closely at the minerals on a solar project. One of the mitigation factors that can be used is the accommodation doctrine, and at its core, it requires a mineral lessee to give due regard to the surface owners. It's a multi-factored test that is extremely fact-specific, but it offers users of the surface state some protection from the idea discussed earlier that a mineral lessee has the right to use so much of the corresponding surface as is reasonably necessary to enjoy the mineral estate. I'm not going to get into a discussion on the factual analysis around each specific element, but I'm just going to give a general overview and a few details. And the first element is, at the time of the mineral lessee's proposed use, the surface owner has an existing use on the land. And this means that the surface owner only benefits from the protection of the accommodation doctrine if there is an existing surface use in place before the mineral lessee begins drilling operations. This is actually one of the issues that came up in the Midway Solar case but they spun it around a little bit to the mineral owner. But so we're going to get into a little bit more discussion later on this. But if a wind solar developer wants to build and operate a facility on a certain parcel of land that is encumbered by a mineral lease, the wind developer or solar developer will have no protection from the accommodation doctrine until the surface use using the wind or solar project commences. And the law has not been developed in this area yet. It is not clear on how this element would apply and what level qualifies as existing use. But if a project is up and running, I think that is obviously existing use. But if it commences construction, that may not rise to the level, and then we take a court to do an analysis of where the project was. The second element is the mineral lessee's proposed use substantially interferes with the surface owner's existing use. This requires that the surface owner to prove that the existing use of the surface is completely precluded or substantially impaired by the mineral lessee's use. This, again, is a fact-specific analysis, but the burden is on the surface owner to prove this. And it would likely be more difficult for a wind developer to prove this element, whereas solar, it would likely be easier because, as we mentioned, wind can be adjusted much easier than a solar project. The third element is the surface owner has no reasonable alternatives to its existing use. This means that the surface owner must prove there's no reasonable alternative by which to continue the existing use. And to prove this, they have to show that there is no alternative location or configuration available on the leased premises, and the financial burden of continuing the existing use by the alternative method is so great as to make the alternative method unreasonable. So in a solar context, this would mean that the expense and cost of moving the facility would be so great as to make it unreasonable to force the facility, or vice versa for wind. Again, it would likely be a little bit more difficult in a wind context. And so it's inefficient for the surface owner to prove that a reasonable alternative method is merely inconvenient or less economically beneficial than the existing method. And the final element is that the mineral lessee has to have no reasonable alternative available that would recover the minerals without interfering with the surface owner's existing use. The accommodation doctrine requires the surface owner to establish that there are alternative, reasonable, customary, and industry-accepted methods available to the mineral lessee, which are located on the leased premises, and which would allow recovery of the minerals while also allowing the surface owner to continue the existing use. And so this would be, for example, a vertical well versus a horizontal or directional well, because directional and horizontal drilling is an accepted industry standard. As long as that drilling, directional or horizontal drilling, can occur on the premises in question, that would be an argument to make. However, the Texas Supreme Court said in Getty Oil versus Jones, if there is only one manner in which the minerals can be extracted, then the mineral lessee's use does not need to be reasonable unless lessee may pursue such use regardless of surface damage. And these are, I'm talking in particular in Texas for the Texas accommodation doctrine, but there's other states that have the accommodation doctrine, and this is the general sense. So I'm focusing strictly on Texas, but this could also be applied, and we'll need to look in other states to confirm the elements, but these are general accepted principles. So as mentioned, the accommodation doctrine requires that an existing use be put in place at the time of the mineral lessee's surface use, and that's not a fully resolved issue in Texas and many other states, and it's a fact question, but obviously the project has to be at least started to build is the general accepted principle. There's a lot of fact-specific, as I mentioned, questions that go into this analysis, and the longer the project is in use and the farther it's been developed and set there and operational, the more likely that it is that the accommodation and existing use factor would be applied. But because of this, most title companies do not typically rely on the accommodation doctrine. In most situations, obviously it's a case-by-case basis, and we can use our analysis that Danny's mentioned to work with the title companies. But typically on a solar project in particular, a set-aside or surface use agreement is going to be required. But there has been a recent development in the accommodation doctrine, and I'm going to get into that case now. the case was Midway Solar, and it was a Texas case that renewable energy developers can, I took it as a win, and that can be used in assessing their minerals. First, the court actually acknowledged that Texas was the leader in energy and produced the largest share of oil and gas, but that public policy favors adding renewable energy sources into the state's energy portfolio, which I believe is a great development, and based on past Texas court cases, has been most of the time favors minerals. This was a good development for the renewable energy industry. This case focuses on the conflict between the surface owner and the solar owner, or the solar lessee, and the mineral owner or developer, which is always an issue, especially for solar developers. The opinion did not address any really fact-specific analysis that must be performed when applying the accommodation doctrine, but it can help confirm that the accommodation doctrine does apply when the deed or the contract between basically the reservation that severed the minerals does not address the uses of the surface. It sets when the application of the accommodation doctrine should be used, and it showed the importance of attaining the agreements and setting aside areas for development. So the quick facts of the case was that the Lyles were a partial mineral owner on a 315-acre tract of land where the developer acquired a solar lease from the surface owner. The Lyles, the mineral owner, were not under any oil and gas lease. They had no plans to develop and had not been approached for a lease. The solar developer designated two areas for set-aside areas on the north end of a section and the south end of the section. The developer pursued surface waivers and ultimately acquired them from 20 individuals, but those individuals appeared to own on adjacent property, but it was purported to waive an interest on this 315-acre tract of land. The developer realized this and amended the waivers and filed a disclaimer of interest, and which disclaimed any interest that the waivers may have given the developer on this 315-acre tract. They constructed the solar facility on 215 acres, and which consisted of approximately 70% of the survey and avoided the drill site tracts. So they set aside areas for development within this 315 acres and covered up 215 of the 315 acres. The mineral owner sued the developer and the surface owner and the mineral owners who signed the set-aside agreements, and claimed that the mineral owner, the Lyles, were entitled to a quiet title declaration because the surface waivers put a cloud on title, that the reservation from a 1948 deed, that deed denied them reasonable access to the minerals by covering 70% of the facility. So basically, they're making a claim of the accommodation doctrine, that their deed reservation is being breached, and that all parties trespass on the mineral owner's mineral estate by the solar lease and improperly executed surface waivers. And the solar developer, and the surface owner filed summary judgment motions that were granted by the trial court, and basically the trial court stated that the disclaimers of interest did not cloud the title, that the accommodation doctrine applies to the interpretation of the deed, and the developer owned no duty to Lyles to accommodate their rights to the surface because of the Lyles, the mineral owners, were not doing any development and had no plans to do so. Obviously, the Lyles appealed this And the appeals court held first that the accommodation doctrine didn't apply to the 1948 deed. And because that deed, which was basically a standard mineral reservation, it had no anything special that I saw in the deed. It basically reserved the right to use the minerals and the right to access the minerals, is basically what the deed said. So the the appeals court agreed with the trial court, and that it did not grant any additional interest or drilling method, and did not limit the surface owner's right to use the surface. And then second, the court confirmed that the accommodation doctrine applied, and when it looked at whether the solar developer must accommodate the mineral owner's potential use of the property before the allows actually or potentially are using the property. And the argument made by the mineral owner was that they suffered damage because they were unable to pursue mineral development because of the solar farm constructed on 70% of the surface. But the court disagreed and stated that the court has to look at actually what's logical in addition to the law. And since the solar developer already had the right to develop the surface, whereas the mineral owner only had the right to use the surface for mineral development, they weren't doing that. The mineral owner was not developing anything. So it's logical to allow the solar project to go on. The court also ruled that if the Lyles are not seeking to develop the minerals, the solar developer owns no duty to them regarding the surface usage because there's nothing to accommodate. The appeals court also stated that even if the accommodation doctrine was misapplied, so even if the Supreme Court said you couldn't use the accommodation doctrine here, in an appeals court mind, they would still reach the same conclusion because the solar developer is not trespassing on the mineral owners until they actually seek to develop, and the mineral owners have not actually asked to enter onto the surface to develop the minerals. So their claims, the mineral owners' claims are premature. So what the court was basically saying is, even if there was a 1948 deed that created a larger interest in the accommodation doctrine doesn't apply, you can't bring a claim because you have no right, you have no plans and no lease to develop the minerals. So that it basically was a big boost to the accommodation doctrine in Texas, and the way I read it, it was a good outcome for the renewable energy industry. There was one more claim that was the quiet title action because the surface waivers were from mineral owners that owned on adjacent property, but the mineral waivers purported to cover that 315-acre tract, which the mineral owner said was a cloud on their title, and the solar developer said it wasn't actually a cloud because we filed disclaimers. I'm not going to go into much detail on that because the court got into a pretty detailed discussion and broke up the waivers into two tracks. But I'll just note that the court agreed in part with the Lyles that a cloud could have been created, and like I mentioned, there is a detailed discussion. And for more information on this case, I've written an article that is actually on the resource tab, and we also have links below if you want to get more details on the case. So this case is up at the Supreme Court. As a petition for review was filed, but overall, I think it's a great development and adds to the long history of the accommodation doctrine in Texas. And like I said, I think it's a good win for renewable developers. And so now I'm going to turn it back over to Danny to discuss non-Texas accommodation doctrine matters.
Yeah, thanks, Brian. So as Brian said, I'm going to lightly touch on non-Texas accommodation doctrine. So when it is determined that there are severed minerals or oil and gas production on a project site, one of the first questions generally asked to us is whether that state has an accommodation doctrine. So while several states do have an accommodation doctrine, many do not. So if a state you're working in does not have an accommodation doctrine, you should perform some research to determine if the state has a statute that deals with surface damages caused by a mineral owner. So for example, Oklahoma does not have a common law accommodation doctrine, but it does have a Surface Damage Act that requires a mineral lessee to reasonably accommodate an existing use of the surface. So just like the accommodation doctrine in Texas, there are a lot of fact-specific questions that go into the analysis, whether in Oklahoma or other states. So as Brian mentioned for Texas, title companies generally won't rely on fact-specific statutes and will require set-aside or surface use agreements to be executed by operators and severed mineral owners. So if a set-aside or surface use agreement is unable to be obtained, you can also work with the title company to obtain an indemnification. And now I'm going to discuss site selection. So, when you're developing a project on land, that has known past or current oil and gas production, the developer of the project will want to use the research conducted on the state websites that we discussed earlier, to find the active or plugged or abandoned wells on the project. So if that information includes the locations of the active oil and gas or mining development, these locations should be overlaid onto any site plan or survey being prepared, so we can make sure we avoid those locations. So the set-aside locations or drill site areas will need to be placed on the survey, to ensure no project facilities are placed within the drill site areas, unless the set-aside or drill site agreement follow or allow facilities within the drill site area. So also the developer, they may also want to consult with an engineer and have them perform an assessment of the oil and gas development on the project site. Generally the engineer can just assist with set-aside areas for the oil and gas operators, which will allow them to continue to efficiently produce oil and gas in compliance with state regulation, especially in active areas. So just in addition to providing set-aside areas for active wells and areas for future development, the engineers will also just provide information regarding plugged and abandoned wells, which is really important because the project company will want to avoid placing their solar panels or wind turbines directly over these areas. And now I'm going to turn it back over to Brian to discuss risk mitigation.
Thanks, Danny. And I'm going to speed through these because we've touched a little bit on these set-aside agreements and surface waivers. But surface waivers are the less common of the agreements, but most preferable. And they do exactly what the title implies. They waive the mineral owner's right to enter the surface for mineral development. Now, the mineral owner can still use a off-site location and horizontally or directional drill, and typically we put into the agreement that depth that they have to be at is 500 feet, but each project can be looked at to make sure that depth severance is the correct for your project. Or many mineral owners will request to go lower, and you can use your development construction teams, and we can walk through what that proper depth is. The more common of the two agreements are the surface use and set-aside agreement, and these are agreements that set aside areas. They waive the right of the mineral owner to use the surface only in these specific areas, and typically those amounts are, if you're doing a drill site area, will be 2 to 7 acres, or I've also seen them done as the north quarter of the property or the south 200 feet, something that works for your project. But these are the agreements I think that are especially need to be looked at for the project, because especially if you're doing a set-aside area, say the north quarter of the property, many times you need to put something through that north quarter, for example, a collection line or a road. And so you want to make sure that the language in your agreement is specifically negotiated with the mineral owner, and that you have that right to place a road or a collection line, transmission line in the area, even though that area is set aside for drilling. The other contract mitigation is express surface waivers in the lease and non-interference. Most of the leases should have this provision, but you just want to make sure that you do include these types of provisions, especially if your landowner is also a mineral owner. It's even more imperative. The other risk mitigation is title insurance, and I'm going to discuss really quickly the Texas endorsements, and then Danny will quickly touch on the non-Texas. But the Texas, you have the 19.1, 19.2, and 19.3, and the 19.1 is can be expensive, but it is a comprehensive endorsement that covers multiple issues, but it covers violations of covenants, conditions, and restrictions on the land, encroachment, damage to improvements due to mineral production. So it is an important endorsement to give. The 19.2 and 19.3 is different than the 19.1 as it only covers damage due to mineral production. It's much less expensive, but 19.2 covers damage to improvements located on the land on or after the date of the policy due to mineral exploration, and 19.3 covers permanent buildings. Typically, the 19.2 is the endorsement added, but we can also add the 19.3 as well. And typically, your financing parties will require the 19.1 and 19.2 endorsements, but it is negotiable as some financing parties have accepted the 19.1 only. Then you also have express coverage, which the language is there. It is a requirement in the policies for most financing parties, and it is basically an additional coverage to the 19.1, and you can see the language there as well. And I'm going to skip over it since we're running a little bit out of time. But Danny, if you want to turn it quickly over to Danny to discuss the ALTA endorsements.
Yeah, thanks, Brian. So in ALTA states, there are just two primary mineral endorsements you can get on an owner's and loan policy. They are the ALTA 35.3-06 and the ALTA 35.2-06. The important thing to note on this is the ALTA 35.3-06 for pre-construction, and it deals with existing and future building and structures, while ALTA 35.2-06 deals with existing improvements. And to obtain either endorsement, just as in Texas, the title company is going to require verification there are no severed minerals or surface waivers or accommodation agreements. Also, some projects may require affidavits of non-production or other mineral curatives, so each project, should just be looked at to determine what is required. And now I'll quickly go over some best practices that we recommend. We recommend working with the title company and underwriting just early so we can confirm there are no mineral issues or surprises with issuing the express coverage or endorsements. You should start mineral searches and contact mineral owners very early in the development process, especially if the mineral ownership is heavily severed. That's important. And you need to do the necessary research so the development and financing of the project is not held up by minerals. And now I'm going to quickly turn it back over to Brian for common issues in real estate.
Thanks, Danny. And just quickly, one last poll question of what types of real estate issues have come up on your projects, and facility easement crossings, overhang issues, title ownership issues, or all of the above. And yeah, it looks like all the above is the major winner there with easement crossings. So these are, I'm going to briefly talk about these, but this is not an exhaustive list, but it is what we commonly see. So the facility easement crossings are when you have an easement that the surveyor can plot and your facilities are crossing it. You do need a crossing agreement on a restrictive easement. If you have a non-restrictive easement that you're crossing, you don't have to have a crossing agreement, but you do need to coordinate typically. And that is done by, not 811 calls or things like that, and just working with the easement holder to make sure you don't interfere. The easement itself needs to be looked at to make sure what is restricted and what not. Is some of these easements can get very complicated language, and especially your early easements can be ambiguous. So it's important to review and determine what is considered restrictive and what's not. Then you have the blanket easement crossings, and this is where especially on solar projects, you need to look at these very closely, and I've kind of listed on the slide when a blanket easement will need some type of an agreement, but you can actually, hopefully, in some situations, take what appears to be a blanket easement, and with some necessary work with the surveyor and online resources, you can potentially identify something that looks like a blanket easement and turn it into, you can locate it, especially if you have other easements with these owners. They can identify which easement is theirs. So, for example, if you had Encore who owned 3 easements in an area, then they can say, and one was blanket, they can identify the location of that blanket easement. The other issue that we've seen come up is overhangs on turbine blades, and this is just something to really pay attention to on for as-built projects. Then you had your point of interconnection rights, just making sure that you get to your point of interconnection with your real property rights. And if you need an additional easement, just making sure that you have all real property rights. And this is just another list of additional title curatives that we see on projects. And instead of Danny talking about it, I think we'll just skip over it for now. And if you have any questions on any of these, feel free to reach out to us. But I will turn it back over to Danny for title company requirements.
Thanks, Brian. So it is just important to obtain, a title commitment and perform it as soon as possible to confirm title curative issues, that just may come up that could throw the project off budget or schedule. So having these commitments and performance reviewed and issues spotted, and just discussed with the title company early in the process just allows for an easier path to development of the project. So if projects wait to have title reviewed, it just can cause potential issues down the road because some projects have, a lot of title curative aspects that have to be prepared that can just have extremely long lead times. And then here's just a list. We wanted to provide you with a few links to some pretty recent articles that have been written by Brian and I on mineral due diligence, and also about the Midway solar case that Brian discussed earlier. And just so you know, these can be accessed through the resources folder. And now I will turn the presentation over to Eric to provide a quick legislative update.
Thank you, Danny. I appreciate it. I am going to give a quick overview here of some ongoing activities in Washington, D.C. That are of interest to the renewable energy and utility sector. As folks know, so quickly going over here, we're going to talk about the infrastructure proposal and the President's American Jobs Plan what the current status and the process ahead is for that, and what this means for both renewable energy tax incentives and the clean energy standard. As folks know, in March, President Biden released his proposal for a $2.3 trillion infrastructure package, 8-year proposal that includes funding requests for transportation infrastructure, expansion of electric vehicles, domestic manufacturing and research funding, efforts to expand housing and improve home care, broadband, the electrical grid, and important to all of us here today, plans to extend and renew and grow the renewable and clean energy tax incentives, put in place a clean energy standard, and highly controversially, to pay for all of this investment by increasing corporate taxes, many of which were just recently reduced in the 2017 tax cut package. These have been subject to some ongoing bipartisan discussions. The president is very eager to try and find a bipartisan solution. However, many other Democrats are eager to seize the opportunity they have at the current moment, controlling both the House, the Senate, and the White House, and to move forward after this. So there's some dispute as to whether or not these negotiations are earnest, or if this is a bit more of kabuki theater, going through the motions to act as though we tried, but it may not bear out any fruit. So interestingly, I include some headlines here from the New York Times, Wall Street Journal, Washington Post from the weekend, where the prognosis was very stark. Since that time, today, the Senate GOP issued a counterproposal for a $928 billion bill, narrowing the gap between them and the White House. Still fairly stark gap of at least $700 to $800 billion, and certainly a lot of policy disputes as well. However, from those sort of dour headlines, today I saw one that said, White House sends positive signals on GOP infrastructure proposals. So it remains somewhat of everybody's best guess what direction it takes. However, this is probably the best question in DC, and which direction it will take, and whether this is a partisan proposal moving forward, or if there's some sort of bipartisan opportunity moving ahead. We do have yesterday the Senate Environment and Public Works Committee moved its own portion of a bipartisan transportation bill on a universally supported vote. But at the same time, we expect the House to move its transportation bill in the coming weeks, likely on a party line vote. And a Democratic chief of staff told me this week that he expects the Budget Committee to begin the process of reconciliation as soon as the week of June 8th. So quickly on budget reconciliation, this is a budget process that was conceived of in about 1974. It establishes a process by which measures can pass the Senate without filibuster, where it takes only 50 votes to pass. However, there's a trade-off. These things must only be used for budget issues and cannot be used for policy. That creates curious questions that are very difficult and fall into the lap of the parliamentarian. The process requires all committees to report out legislation that then gets assembled by budget committees, so it is cumbersome and is unpopular widely, both among senators and staff, because there are steps along the way called a vote-a-rama, in which votes can be taken on a range of different policies over a very condensed period of time. Moving ahead, just quickly, what this means is that the House and the White House have both put forth 10-year proposals to extend the current framework for energy tax credits for the PTC, the ITC, and to make some expansions to include grid and transmission and energy storage. The Senate, however, has taken up a new approach. This was cleared in the committee yesterday on a party line vote of 14 to 14. It would create a technology agnostic approach where the taxpayer can select to use either the production tax credit or the investment tax credit, and that the sunset of these would not be based on a calendar time frame, but on achievement of certain clean energy and carbon emission goals to 1/4 of the current 2021 levels. That will be expected to be included in the package moving forward, and we will report on that next month. Thanks so much. Back to you.
Thanks, Eric. Thank you for joining us today, everyone. We hope that the information was helpful to you and your organization. Just as a reminder, this program has been approved for continuing legal education hours. So to report your hours, just click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. This concludes our webinar. Thank you.